الجامعة الإفتراضية السورية كتاب Criminal Law القانون الجزائي by عماد الدين محمد الوحدة التعليمية الثانية Chapter 2 يغطي هذا التسجيل الشرائح من 22 وحتى النهاية Slide 22 until the end. تقدمت مبادرة ضوء بصوت دانة بيرقدار. Slide 22 Causation. So, the actus reus of an offense may comprise of a number of different types of actus reus elements, conduct, consequences, and circumstances. We will now explore the way in which the law deals with offenses which require proof of a consequence. These are referred to as result crimes. Where a defendant is charged with a result crime, the prosecution must prove that the defendant caused the result in order for the actus reus to be satisfied. Slide 23. Causation. Example. To establish the actus reus of murder, the prosecution need to prove that the defendant caused the death of the victim. There must be a chain of causation between the act or omission of the defendant and the result. It is for the jury to decide whether or not the prosecution have proved beyond reasonable doubt that the defendant caused the necessary result. Two main rules of causation. 1. The prosecution must prove that the defendant was the factual cause of the result. 2. The prosecution must prove that the defendant was also the legal cause of the result. The test for the actual causation is the but-for test, and it must be established that but for the defendant's actions, the result would not have occurred. Slide 24. Causation. Legal causation is referred to as the chain of causation, and the prosecution must prove that there was no novus actus interveniens, in other words, new intervening act, which broke the chain of causation. If the chain of causation is established, then the defendant will have caused the result and may be guilty of an offense if the remaining elements of the actus reus and the mens rea of the offense can be proved. However, if the chain of causation is not established due to the existence of an intervening event which breaks the chain, the defendant cannot be said to have caused the result. There is no actus reus and he or she will not be guilty of an offense. Causation can be simple to establish. Example, if Mr. A shoots Mr. V in the head and Mr. V dies as a result, it will be clear that Mr. A caused Mr. V's death. However, there may be a number of events which each contribute to the result. Where such multiple causes of a result exist, the judge must determine which of these causes may contribute in law to the result. Slide 25. Causation. Example with two possible causes. Mr. B shoots Mr. V in the leg. Mr. V is taken to hospital, where he is informed that he needs a blood transfusion, which will save his life. Mr. V refuses to have the blood transfusion and dies as a result. In this situation, can it be said that Mr. B has caused Mr. V's death? Or has Mr. V caused his own death? Does Mr. V's refusal of treatment absolve Mr. B of any criminal liability for Mr. V's death? In this case, Mr. B is the factual cause of Mr. V's death because Mr. V's death would not have occurred were it not for Mr. B's act of shooting him. However, it is more difficult to determine whether or not Mr. B was the legal cause of Mr. V's death, as Mr. V's refusal of treatment may amount to an intervening act which breaks the chain of causation, absolving Mr. B of liability for murder or manslaughter. Slide 26. Causation. Let us now increase the number of contributing factors in this example. Mr. C points a gun at Mr. V. Mr. V is so afraid that he jumps out of the window in order to escape the threat, but in doing so, he sustains a serious head injury. An ambulance is called but arrives an hour late because the driver lost his way. At the hospital, Mr. V is attended by a junior doctor who misdiagnoses the severity of Mr. V's injuries and sends him home. Mr. V returns to hospital a week later as his head injury is worse. This time, a female doctor attends to Mr. V, but Mr. V refuses to allow her to treat him. Mr. V dies from the head injury. Who has caused Mr. V's death? Did Mr. C cause Mr. V's death? Did the late ambulance driver cause Mr. V's death? Did the incompetent junior doctor cause Mr. V's death? Or was it the actions of Mr. V jumping out of the window and refusing to be treated by a female doctor cause his death? Who or what broke the chain of causation? Slide 27, Causation. Applying the rules of causation to this scenario, it is again clear that it is Mr. C who was the factual cause of Mr. V's death. If it were not for Mr. C pointing the gun at Mr. V, Mr. V would not have jumped out of the window and sustained head injuries. An ambulance would not have been required. The junior doctor would not have misdiagnosed Mr. V. Mr. V would not have had the opportunity to have refused treatment by the female doctor, and ultimately he would not have died. However, legal causation also needs to be established, and there are multiple causes in this scenario. It must be ascertained whether any of these contributory factors will break the chain of causation and release the defendant from liability. Slide 28. Factual causation. The prosecution must initially establish that the defendant's conduct was a factual cause of the result. His or her conduct, act or omission, must be a sine qua non, which means without which not, of the result. This is referred to as the but-for test. The but-for test is applied by asking the question, but for the defendant's conduct, would the consequence have occurred? Slide 29. Factual causation. If the result would have occurred irrespective of the defendant's conduct, the factual causation is not established. The defendant cannot be said to have caused the result, and he will not have the actus reus for any offense requiring a proof of causation of that result. If the result would not have occurred but for the defendant's conduct, then factual causation is established. However, this does not automatically lead to liability. To establish the actus reus of the offense, the prosecution would also have to prove that the defendant was the legal cause of the result and that there is no novus actus interveniens which breaks the chain of causation. The case most commonly associated with the test for factual causation actually gives us an example of a situation where the but-for test was not satisfied. White 1910 2KB 124. An example of a case where the successful application of the but-for test was established is Mitchell 1983 QB 741. Slide 30. للاطلاع, legal causation. So, there may be more than one factual cause of a result. Not all factual causes will amount to legal causes. Otherwise, the concept of causation would be far too wide to ridiculous proportions. Example: it could be argued that but for the defendant's mother giving birth to the defendant, he would not have acted as he did. The defendant's grandmother could be another factual cause, as could her mother and grandmother, and so on, further back into history. This would be a silly and nonsensical approach for the law to consider. Therefore, the principles relating to legal causation act as a common sense filter, limiting the number of factual causes which the jury can take into account by law. Slide 31. Legal causation. The prosecution must prove that the defendant's conduct was a more than minimal cause of the prohibited consequence. This is referred to as the de minimis principle, through which the law seeks to disregard any negligible or trifling or silly causes. However, the cases in this area have developed further terminology which is often used in reference to legal causation. A defendant will be the legal cause of the consequence if his or her conduct was the operating and substantial cause of that result. A defendant's conduct must contribute significantly to the prohibited result. Slide 32. Legal causation. للاطلاع. It is a matter for the jury to decide whether or not the conduct of the defendant has a sufficient link to the end result to justify attaching blame to the defendant. As such, the jury are tasked with the making of value judgment. The accused act need not be the sole cause or even the main cause of the victim's death, it being enough that his act contributed significantly to that result. The case of Bench 1865 demonstrates that the accused act need not be the sole cause of the result. So, the defendant's conduct does not need to be the sole cause or even the main cause of the result, but it must be the cause. Where there are alternative causes of a result, the prosecution needs to prove that the defendant was actually a cause of the result. Slide 33. Novus actus interveniens, which means new intervening act. Where the defendant's conduct is a more than minimal or operating and substantial cause of the result, the defendant will be the legal cause of that result unless there is a novus actus interveniens which breaks the chain of causation. If an intervening act does break the chain of causation, the defendant will not be the cause of the result and will be absolved of liability for that result. Slide 34. Novus actus interveniens, which means new intervening act. The types of intervening event which might break chain of causation are: 1. An unforeseeable escape. 2. A voluntary act by a third party or the victim. 3. Negligent medical treatment. 4. A natural event. Policy considerations also often play a part in the court's decisions in relation to novus actus interveniens. Slide 35. The thin skull rule. The thin skull is summarized by the statement, "You take your victim as you find them." A defendant who causes some injury to the victim must take his victim as he or she finds him or her. This means that where the victim suffers from some latent, pre-existing physical condition which renders him or her unusually susceptible to injury, the defendant remains liable for the consequences of his conduct, no matter how unusually serious they are. For example, if a defendant strikes the victim on the head in a manner which would normally cause no injury to a person, but the victim has an unusually thin skull which breaks, or is a hemophiliac, which means that a person may bleed to death as a result of a small cut which would usually not cause any serious injury, then the defendant is liable for the full consequences of his or her act and will be liable for the victim's death should he or she die. A victim's particular susceptibility due to a pre-existing condition does not break the chain of causation. Slide 36 للإطلاع. The thin skull rule. An example of the application of the thin skull rule is found in the case of Hayward, 1908. The rule extends not only to unusual physical conditions, but also covers the whole man. As a result of the case of Blow, the thin skull rule extends beyond mere physical conditions and encompasses religious beliefs. Lawton L.J. took the view that the thin skull rule extended to the whole man. It is not clear what this means, nor how far beyond religious beliefs the thin skull will reach. Slide 37, Escape cases. The chain of causation may be broken by the actions of the victim in effecting an unforeseeable escape. This means that the defendant will not be liable for any injuries that the victim sustains as a result of his escape from the defendant if that escape was unforeseeable. The law distinguishes between the acts of the victim which are reasonably foreseeable and involuntary, and those which are unforeseeable and voluntary. Professors Hart and Honor, 1985, define a voluntary act as one which is free, deliberate, and informed. Such an act breaks the chain of causation. A victim is forced to escape from the defendant as a direct result of his conduct effects a reasonably foreseeable and involuntary escape. This will not break the chain of causation, and the defendant will be liable for any resultant injuries to the victim. These cases are also referred to as fright and flight cases. Slide 38. للإطلاع, escape cases. The test of reasonable foreseeability was applied in Mackey, 1973. The test is whether the deceased's reaction was within the range of responses which might be expected from a victim placed in the situation which he was. The jury should bear in mind any particular characteristic of the victim and the fact that in the agony of the moment he may act without thought and deliberation. Slide 39. Victim's self-neglect. So, there are circumstances in which the conduct of the victim may break the chain of causation. Holland, 1841. Slide 40. The drugs cases. There are a number of drugs cases on unlawful acts, manslaughter, in which the issue arises of whether a free and voluntary act by the victim precludes causation from being established. Kennedy No. 2, 2007, UKHL 38. The defendant prepared a syringe of heroin and handed it to the victim. The victim injected himself with the drugs and later died. The defendant appealed against his conviction for unlawful act manslaughter. The House of Lords held that a defendant was not to be treated as causing the victim to act in a certain way if the victim made a voluntary and informed decision to act in that way. it would not be shown that the defendant had caused the victim to administer the drugs. The victim's free and voluntary act of administering the drugs to himself was fatal to any argument that the defendant had caused the drugs to be administered to the victim. Slide 41. Third-party intervention. An act by a third party might break the chain of causation if that act is a voluntary one which contributes to the result. If the act of the third party does break the chain of causation, then the original defendant is absolved of liability. The separate issue of the third party's potential liability could also be considered. However, an involuntary act of a third party will not break the chain of causation, and the chain of causation will remain intact. Slide 42. Negligent medical treatment. The cases of Smith 1959 and Cheshire 1991 deal with whether subsequent negligent medical treatment can break the chain of causation, absolving the defendant from liability. The courts have taken a strict approach, and the general rule is that the conduct of a doctor, even if negligent, does not release the defendant from liability. A negligent doctor may be liable civilly or negligence, or may even be criminally liable for gross negligent manslaughter where the victim dies as a result of his or her negligent conduct. However, any such liability on the part of the doctor is a separate issue to that of the defendant's liability. Policy considerations largely govern the area of causation. The court does not desire an original attacker to escape criminal sanction because a doctor who arrives on the scene as a result of that defendant's conduct is negligent. Slide 43. Natural events. A natural event which was not reasonably foreseeable, an act of God, will break the chain of causation. As with escape cases, the foreseeability of the subsequent event is the determining factor of liability. Example: the defendant strikes the victim, knocking him or her unconscious, and then leaves him or her in a park on a sunny afternoon, where he or she is later struck by lightning during a sudden storm and dies. If the original injury did not directly lead to the death of the victim, the defendant will not be liable for his or her death, as the bolt of lightning was objectively not foreseeable. So, it will break the chain of causation. However, where the natural event is reasonably foreseeable, if the defendant leaves the victim on a railway track or on a beach with the tide coming in and the victim dies, the natural event will not break the chain of causation. Slide 44. Surrounding circumstances, state of affairs, crimes. The actus reus of some offenses require proof only of the existence of surrounding circumstances. These are called state of affairs crimes. These offenses require no conduct or voluntary act to be proved, and as such are exceptions to the general rule that the actus reus of an offense must be voluntary. The defendant will be guilty of the offense if the prosecution simply prove that a specific set of circumstances exists. These offenses are being crimes, not doing crimes. Slide 45. للإطلاع. Surrounding circumstances, state of affairs, crimes, examples. The offense of being in charge of a motor vehicle on a road or public place whilst unfit to drive due to alcohol or drugs, contrary to Section 4 Road Traffic Act 1988. The offense is committed when this state of affairs of being unfit to drive and in charge of the vehicle exists. The defendant does not need to physically do anything. The offense of having an offensive weapon in a public place, contrary to Section 1 Prevention of Crime Act 1953, this offense is committed if the defendant simply has the weapons. He or she is not required to do anything such as use the weapon. Slide 46. Surrounding circumstances, state of affairs, crimes. Two cases which are examples of prosecution of state of affairs offenses are Windsor v. Chief Constable of Kent, 1983, and Larsonero, 1933. The results of these cases seem unfair. The defendants in both cases were convicted because the actus reus of each respective offense was present. These offenses are unique in that they require no mens rea element to be present. Such offenses are called absolute liability offenses. It could be argued that the actus reus in each case was not voluntarily brought about. Refer back to the text under the subtitle "The actus reus must be voluntary." In fact, the authorities in each case procured the commission of the relevant offense by placing the defendants in such a position as to render them guilty of an absolute liability offense. The extent to which convictions in such circumstances can be fair must be questioned. Slide 47. للإطلاع. Summary. 1. The law does not punish individuals' evil thoughts alone. Some element of actus reus is required. If there is no actus reus, there is no crime. 2. The actus reus of an offense may involve an act or omission, conduct crimes, certain consequences being caused, result crimes, or the existence of surrounding circumstances, state of affairs crimes. 3. The actus reus of an offense must be voluntarily performed. 4. The general rule is that there is no liability for an omission to act. 5. There are 5 exceptions to this: special relationship, voluntary assumption of responsibility, supervening fault, contractual duty or public office, and statutory duty. Slide 48. للإطلاع. Summary. 1. Causation is an actus reus element. Where the defendant is charged with a result crime, the prosecution must prove that he caused the result in order to establish the actus reus of the offense. 2. The test for actual causation is the but-for test. White, 1910. It must be established that but for the defendant's conduct, the result would not have occurred. Legal causation is the chain of causation. The defendant's conduct must be a more than minimal cause of the result, or an operating and substantial cause. Smith, 1959, or it must contribute significantly to the result. Paget, 1983. Slide 49. للإطلاع. Summary. 1. If there is a novus actus interveniens, the chain of causation will be broken and the actus reus will not be established. 2. The types of intervening event which might break the chain of causation are an unforeseeable escape, Roberts, 1971, a voluntary act by the victim, Kennedy, number 2, 2007, a voluntary act by a third party, Paget, 1983, negligent medical treatment, which was so independent of the defendant's act and so potent in causing death that the contribution made by the defendant was rendered insignificant, Cheshire, 1991, and a natural event which was not reasonably foreseeable. 3. The thin skull rule states that the defendant must take his victim as he finds him. This means the whole man, not just the physical man.
below 1975. The chain of causation is not broken by the existence of a latent physical or psychological condition which renders the victim particularly susceptible to unusual consequences. نهاية التسجيل ونهاية الشرائح Chapter 2.